Members, good afternoon. It's the appointed time and we have a quorum. I call to order the meeting of the Panel on Administration of Justice and Legal Services. Agenda Item 1. Information papers issued since the meeting on the 23rd of March. After the last meeting, the Secretariat has not issued any information papers. Agenda Item 2. Items for discussion at the next meeting. Please refer to LC paper number CB-3335/2026-01 and -02. They are the list of outstanding items for discussion and the list of follow-up actions. I'd like to discuss with members about the next regular meeting. The next regular meeting will be held at 4:30 p.m. on the 26th of May. It's a Monday. After consulting the administration, we suggest discussing the following items. 1. Proposed creation of one-time limited deputy principal government counsel post and redeployment of one principal government counsel and one deputy principal government counsel post in the Department of Justice. That's going to be the first item. Second item, Hong Kong Professional Services Go Global platform. I see that no members asked to speak, so we will move on to Agenda Item 3, updates on the provision of legal aid services by Legal Aid Department. I'll ask the Secretariat to invite the relevant representatives to join us. Please refer to LC paper number CB-3335/2026-03 and -04. They are the paper provided by the Legal Aid Department and the background brief prepared by the Legislative Secretariat. While we wait for the representatives to join us, I ask members who would like to speak to press the Request to Speak button. From the administration, we have Ms. Eva Yam, Deputy Director of Administration. We also have with us Mr. C.M. Chen, Director of Legal Aid. Ms. Juliana Chan, Deputy Director of Legal Aid. Mr. Sam Kwan, Acting Assistant Director of Administration. From the two professional bodies, we have with us Mr. Roden Tong, President of the Law Society of Hong Kong, Ms. Melissa Pang, Past President and Chairlady of the Legal Aid Committee of the Law Society of Hong Kong. We also have with us Ms. Kelly Lam, Deputy Secretary General and Director of Practitioners Affairs of the Law Society of Hong Kong. I also welcome Mr. Jose Antonio Morolet, Chairman of the Hong Kong Bar Association, as well as Mr. Neville Leslie Cerrone, Chairman of Standing Committee on Legal Aid Reform of the Hong Kong Bar Association. We also have Ms. Bonnie Lai, Director of Administration and Development of the Bar Association, as well as Ms. Connie Yao, Public Relations Officer of the Bar Association. Here I will first ask Ms. Eva Yam, Deputy Director of Administration, to walk us through the paper. Afterwards, I'll ask Mr. C.M. Chen, Director of Legal Aid, to supplement. Ready when you are, Deputy Director. Thank you, Madam Chair. Today, we are happy to be here. Last year, together with the LAD, we were also here to report to members on the latest situation regarding the provision of legal aid services. So we are very happy to be here today again to report to members on the latest update. We will listen to members' concerns and we will try our best to respond to members' questions. Now I will pass the floor to Mr. C.M. Chen. Director of Legal Aid. Thank you, Madam Chair. I took up the post on the 2nd of January this year, and this is my third time at LegCo attending meetings. Last week, I attended a special FC meeting, and today I'm at the Panel on Administration of Justice and Legal Services. Today, we're here to tell members the latest situation regarding legal aid services. Since I took up the post, I have been stressing that we have a stable legal aid system in Hong Kong. The work of the LAD is crucial to maintaining the rule of law in Hong Kong. Under our system, we ensure that those who are in need would be able to get legal aid services. Apart from ensuring effective use of resources, we promote the use of technology so that we can move with the times. We also step up publicity. I also lead my colleagues in the LAD to communicate with various stakeholders so that members of the public could understand more about our work. Here I'd like to thank Mr. Nick Chen. He lined up the two professional bodies as well as Legislative members, and he coordinated a meeting on the 20th of April. And in the meeting, we exchanged our views with each other on training up legal professionals, facilitating those who are capable to join the legal aid panel, stepping up regulation over assignment of cases to enhance transparency. All these were touched on during the meeting on the 20th of April. Here I'd also like to thank the two professional bodies as well as Legislative members that attended the meeting that day. They offered a lot of valuable views. The LAD will work very closely with members of the legal sector so as to fulfill our mission. Today, we welcome members to raise any questions on the administration paper. We will continue to listen to your views and step up communication with various sectors. Thank you, Director, for leaving time for discussion. Now, I will invite Mr. Jose Antonio Morales from the Hong Kong Bar Association to speak afterwards. I will invite Mr. Neville Leslie Sereny to speak. Madam Chair, here I would like to congratulate Mr. C.M. Chen for being appointed as the director. Our association has been working with the LAD. We believe that under Mr. Chen's leadership, they will achieve an excellent job. Here, I will say a few words about our work on providing legal aid services. Afterwards, Mr. Neville Leslie Sereny will supplement. In a society with rule of law, legal aid services are crucial. The objective of legal aid is to ensure that everyone who has reasonable grounds for pursuing or defending a legal action will not be denied access to justice. Legal aid services cover criminal legal aid cases. Second, personal injury claims. Third, matrimonial litigations. These three types of cases account for the majority of legal aid cases in Hong Kong. The Bar Association understands that the LAD strives to distribute resources and work evenly, and that it strives to avoid any over-concentration of cases on one party. This is to ensure the interests and protection of the legally aided persons. This is very important. Now I'd like to pass the floor to Mr. Sereny. Mr. Sereny, please.
Very much. And thank you for giving us the opportunity to be able to speak to you on behalf of the Bar in relation to this very, very important subject. The Legal Aid Department is a pearl in the straw. It is not a second-class service. Its many achievements are seriously unsung. The countless victims of industrial accidents, clinical negligence, and such like, leading to quadriplegia, brain damage. Those victims have only secured proper compensation thanks to the Legal Aid Department having instructed leaders of the profession in their respective fields. The public is largely unaware of these successes. And this is because the insurers insist on confidentiality with regard to the amounts of damages awarded or negotiated. And when they are reported, the role of the legal aid department is rarely publicized. Contrary to the myth, which is largely circulated by legal practitioners who do not subscribe to the legal aid panel, the service provided is first class. As many of you will know, I have been practicing in Hong Kong since 1986. And one of the first things that struck me was how outstanding the legal aid service was in Hong Kong. I would go so far as to say probably the best in the world. Through subscribing to the legal aid system by barristers and solicitors, though it's voluntary, it is a public duty which is performed proudly by those who join it. There are, unhappily, too many barristers and solicitors who do not subscribe to the legal aid service. And when their clients run short of funds, they say goodbye. This is a serious derogation, in my view, from their professional obligations. To all intents and purposes, the legal aid department is a very large firm of solicitors. It is staffed by legally qualified officers, and like their counterparts in the private sector, they are professionally obligated to instruct counsel with the appropriate level of competence and experience for the particular case for which they are assigned. The bar, like the medical profession, is divided into areas of specialization. Instructions to barristers have to be according to the specific demands of the case for an appropriate level of expertise. The assignment of counsel by legal aid department is not a cake to be shared out evenly. Assignments have to be made on a professional basis. Hamstringing the legal aid department with artificial limits on the number of cases to be assigned to counsel, or capping the amount that they can earn in a 12-month period, imposes an artificial restraint on the proper exercise of judgment by the department's professional officers. Changing to another aspect, regrettably, the fees paid to counsel and solicitors under the legal aid scheme are disproportionately discounted against market rates. This is possibly one of the reasons for a number of people not joining the legal aid panel. But it is particularly acute in relation to fees for criminal legal aid. The bar's experience evidences that given sufficient funding and discretion, it can rely on the professionalism of the legal aid department's staff to assess fees in criminal cases at a more realistic level. If I may say so, our message to the administration is to recognize the outstanding contribution that the legal aid department has made, enhancing Hong Kong's reputation for a fair system of justice, and to allow the department's counsel, under the direction of Mr. C.M. Chan, a greater measure of discretion in relation to both the assignment of counsel and the fees paid to them. In this way, it will enable the department to continue to earn both international and domestic respect and admiration for the work that it does. Thank you.
好，唔該。咁跟住咧，我就想請香港律師會
Thank you. Now I would like to invite Mr. Rodan Tong, President of the Law Society of Hong Kong, to speak first, and then Ms. Melissa Pang. Thank you, Chair Lady. Director of Legal Aid, dear members. Seeking legal justice is one of the basic human rights, and it is also protected by basic law. In Article 35 of Basic Law has protected such right of any citizens, and they also protect a right to seek a qualified legal representatives and also to receive just compensation. Therefore, legal aid is one of the very important part of the system. We also support its core to make sure that anyone with a reasonable grounds for pursuing or defending a legal action in the Hong Kong courts will not be denied access to justice because of a lack of means. We also agree that through the scrutinization of means and merits, we have to make sure appropriate use of public fund and to uphold the credibility of the system. The Hong Kong Law Society always monitor very closely the work of legal aid department. Many of our members also receive legal aid case. Our committee will also review related issues on a regular basis in order to reflect what we're concerned, including enhancing publicity of legal aid services to optimize the handling of such applications and speed up the payment as well as compensation, speed up the evaluation of the payment of the solicitors or the counsels. We are very glad that the legal aid department has been improving in many areas. For example, to prevent over-centralization of this assigning of case, to support legal aid applicants to use mediation and to take on the reasonable fees concurred by mediation, as well as upgrading the services of legal aid. There are also some observations that I would like to allow to Ms. Melissa Pang, past President and Chair Lady of the Legal Aid Committee of Law Society of Hong Kong, to share with you all. Ms. Pang? Chair Lady, Director of Legal Aid, fellow members, thank you for this opportunity for me to join you all in order to reflect our concerns about some practical aspects of legal aid. There are two key points that I would like to raise. First of all, regarding the solicitors, the litigation solicitors, the numbers of such assignments actually only amount to a very small proportion of all cases. Since 2021, the qualified lawyers will be able to have the framework who allow them to speak in the High Court, the Court of Final Appeals, etc. Such frameworks has confirmed their ability in litigation, and it is also enabling a more cost-effective court litigation service foundation. At this moment, members of Law Society of Hong Kong, we already have 211 litigation lawyers, showing that it has been progress in a very stable manner. We hope that there will be more assignments of appropriate cases so that they would be able to work in this capacity, so that the legal aid participants will be able to receive comprehensive and one-stop legal services by one lawyer. Second, the Law Society also expects that the legal aid department can increase assigning legal aid cases to some junior lawyers. Some young lawyers expressed that it takes a long time for them to apply to go on the legal aid panel. Some of them even have to wait for 1 year. We hope that the legal aid department can expedite the vetting of these applications so that they can become one of the lawyers on the legal aid panel. In the future, the Law Society of Hong Kong look forward to work together with the legal aid department in many different areas to co-organize different talks so that legal aid department can strengthen their explanations
regarding the applications for legal aid panel. We believe that a stringent and reasonable system of legal aid is a crucial foundation of upholding the rule of law and our confidence in law across Hong Kong society. We look forward to our future cooperation. Thank you. Now I would like to give the floor to members to raise questions. As I can see, 8 members has expressed their intent to speak. Allow me to read the order. Ms. Maggie Chan, Mr. Nick Chan, Mr. Thomas So, Mr. Wu Yingpang, Ms. Priscilla Leung, Mr. Alex Fan, Mr. Tang Ka Piu, as well as Danny Leung. I will allow for 4 minutes. Questions and answers include, first, Ms. Maggie Chan. Thank you, Chair Lady. As I can see, right at the beginning, the Director of Legal Aid has mentioned that on one hand, we have to allow every single one in the society would have the means to access justice. We also have to train up and increase the equality of lawyers in accessing the case, as well as nurturing future talents. I really agree. Well, since Mr. C.M. Chan was new to his position, but still he has already stipulating the highlights of his work, and these are the demands from the sector. I have some questions regarding the approved legal aid cases. Well, in other words, they have passed the scrutinization regarding the means as well as the merits. However, in the process, in the middle of the process, well, the certificates only support them till a certain point. After that point, maybe the counterparty has disclosed documents showing that there is no reasonable reasons for success. Sometimes the counterparty will write directly to the legal aid department saying that this applicant or this particular person has no merits for their case. How would you view these kind of practices? In the process, if you see some issues with the merits test, how many of them would be suspended from the legal aid provision? What is the percentage claimed? I am one of the members of the legal aid panel. Thank you, Chair Lady, and thank you for your support to me as well as my job. Regarding the specific question Ms. Maggie Chan has asked, well, there have been legal aid certificates that was provided as a limited certificate. Well, as I emphasize, on one hand, the legal aid department would like to seek justice. On the other hand, we also have to be careful in taking care of public fund. Therefore, sometimes we will issue legal aid certificates with limitations. Sometimes there is a time limit. After a period of time, there needs to be some reviews. If the 2 tests will continue to be passed, that is the means test as well as merits test, we will continue providing the aid. I don't have the statistics here with me. Maybe the Deputy Director can supplement to me. Well, actually, this is us being the gatekeeper. We are not going to approve legal aid in a one-off manner. Instead, we will continuously monitor the progress of certain cases. If the situation changes, we will evaluate it. There is a possibility for us to revoke the legal aid certificate. See if Deputy Director have anything to supplement. Yes, thank you for your question. According to the legal aid ordinance, we will also look into the continuous merits of that case. As mentioned, that is a representation system. The reason why we have this system in place, well, if there is any party, either a party from the general public or either party of the case has issues regarding the provision of legal aid. Well, since we are using public fund, so in light of a reasonable use of public fund, we will allow such party to provide us with their presentation. We will also have a mechanism in place the applicants would have the chance to provide their own representation. Let's say the counterparty has written to us saying that, well, as we scrutinize the process, we have missed out certain information, and they will provide us with new documents. Upon the approval of certificate, we will still be open to new documents. If there are new discovery showing that there has been cases of fraud or non-disclosure, we would also allow the applicants to meet with our legal aid lawyers so that they can explain to us the grounds that they should continue to receive legal aid. We will listen to both parties before making our decisions. Upon listening to both parties, we believe that legal aid shall be suspended. And if the applicants would like to appeal, there is also a free of charge appeal system. In 2025, we have 166 cases where we believe that the applicants do not have reasonable grounds to continue with their case. Therefore, we have suspended the aid. No follow-up questions? Ms. Chen, very detailed response. Thank you. Next, Mr. Nick Chen, Chair Lady, Director. Well, thank you very much for your appreciation. Actually, all credits belong to you and the two professional bodies. I have two questions. Well, the first question I ask on behalf of my sector. On one hand, many of them would like to support the work of legal aid, but on the other hand, they would feel that they have to, it's like paying in advance. And it takes a long time for the payment from legal aid to be provided back to them. So regarding the payment structure of legal aid, I know that this is something that you are working already. How can we shorten the process of evaluation and how can we speed up payment? I hope you can provide us with some updates in this regard. Second, well, Director, recently, there are some legal bodies coming to Hong Kong from the West, and they are speaking under the banner of human rights. They said that while some of the participants have passed both the merits and means test, however, they were not able to nominate their own lawyers. Is it a political vetting, or are there other reasons? Two questions, Director. Thank you, Chair Lady, and thank you, Mr. Nick Chen, for your questions. First of all, regarding the payment to the legal aid lawyers, you asked about our efficiency. I would not say that it is a problem. Right at the beginning, I have already said that the legal aid department has a role to keep the gates. Well, lawyers, as a professionals, will not charge just casually. However, it is our position to keep the gauge to see whether it is truly reasonable. Well, sometimes when we have to ask questions and wait for responses, the back and forth would take time. We do have our performance pledge. From my information, 90% of our cases fulfill the efficiency stated in our performance pledge. Looking forward, we do recognize that there is room for improvement. Under the arrangement of Mr. Nick Chan, we have already initially discussed with the two professional bodies. For example, perhaps we can invite the law firm to provide documents to us in the form of some templates. Now, different law firms would have their own ways of presentation showing the charges. It might not be the same as the legal aid department, and it takes longer time for us to communicate with them. If we have a uniform template for billing, it might speed up the process. All these suggestions are what we truly welcome. That's why I said it is very important for us to communicate with the two professional bodies. It is truly helpful. Second, regarding certain foreign parties who don't really know the reality of Hong Kong, maybe they have some unjust comments on us. Allow me to speak generally. As I said, Legal aid is one of the core values of the rule of law in Hong Kong. That is, to ensure people to have access to justice just because they have lack of means. Well, either you are pursuing for legal actions or defending from legal actions, we will support you. It covers both the civil and criminal cases. In 2021, after our reform for criminal cases, regarding to the nomination of counsels, after 2021, truly, the participants can no longer select their own counsel. It will be assigned to them because it is an appropriate use of resources. And you also want to look for the most suitable law representative for the applicant. For civil cases, they still have the right to nominate. They can make suggestions of who to hire, and we will have a series of considerations. Is this lawyer the most suitable one? Are they able to seek the largest possible degree of justice? We will also consider the the level of professionalism.
Director, would the competence as well as experience be some of the criteria you would take into consideration when assigning the cases to lawyers? Yes. Counsels and solicitors have their own expertise, and applicants a lot of times may not be very familiar with individual lawyers. They may have heard that some lawyers are very good, but what do they mean by good? So we would consider applicants' views, and we would offer our advice to applicants, telling them that, for example, this is a civil case, and we would recommend a certain lawyer to the applicant. So definitely experience as well as the backgrounds of the lawyers are taken into consideration. Next, Mr. Thomas So. Thank you, Madam Chair. I thank the Director for briefing us the work of the Legal Aid Department. I totally agree that this is the right direction to take, and I thank the administration for the report. I have some questions about conciliation services. I have to first declare interest. I am a mediator, and I am also the chairman of EBRAM. In 2026, mediation service was first included in your report, and that was mentioned in paragraphs 22 and 23 of your report. In 2023, there were 620 cases, 2024, 656, and 2025, 543 that were approved to incur expenses for mediation. According to the paper, this helps save about 50% of legal costs, and about 26% of time was saved with the use of mediation. In 2025, the number of legal aid certificates with mediation was 3,690. A lot of these cases could use mediation. However, in the same year, the number of approval was only 543, accounting for just about 14.7%. This shows that there is room for improvement. I support the use of mediation so that we can become a capital of mediation. I noticed that over the past 3 years, there were 620 cases, 656 and 543 legally gated cases with approval to incur expenses for mediation. On average, every year we have some 3,000 civil legal aid cases, and the number of cases that use mediation account for just about 10 to 20%. My question is, in 2025, there was a drop of about 100 cases with approval to incur expenses for mediation compared to 2024. What was the reason behind? Also, can we increase the percentage of cases that use mediation? Are there any specific plans this year to increase the use of mediation in legally aided cases? Director, I thank Mr. Thomas So for the questions. Concerning question 1, that is, the number of cases approved for mediation in 2025 saw a drop of about 100 cases. Well, is it because mediation has become less popular, or is it that we have done less on promoting mediation? Well, not every case is suitable for the use of mediation. For some cases, mediation may not be the effective solution. The LAD is in a rather passive position. We have to look at the nature of cases that come in, and the composition of these cases vary every year. So we don't have a specific target of how many cases should adopt mediation, but I have to stress that mediation is a very important means for resolving disputes. So the LAD supports mediation. As we all know, for civil cases in Hong Kong, there are specific parts which require mediation, and we ask our assigned lawyers to follow these specific procedures. So mediation has a role to play in civil cases. In our internal discussions, we do hope that there could be wider adoption of mediation. As mentioned, mediation helps save manpower and costs. It helps reduce costs, as well as it helps clear the backlog of cases we have. So we will think about how we can further promote the use of mediation in legally aided cases. As for whether we have any specific plans, well, I am in talks with my colleagues to see how we can encourage more legal aid applicants to use mediation to resolve disputes. This is an important item on our agenda. I thank Mr. Thomas So for the reminder. I will report to members where appropriate. Professor Priscilla Leung. Thank you, Madam Chair. I have been concerned about legal aid. The first motion I move as Legislative member is to fight for more legal aid services for the middle class. Over the past 10 years or so, I see that legal aid services cover a wider area, including the middle class, and I'm happy to see that. In 2021, there was a reform. I agreed to the reform because we don't want to see over-concentration of certain cases, be they JR cases, civil or criminal cases, on certain lawyers to avoid championship. I think we are heading towards the right direction. With this great progress, I thought of what I tried to achieve starting from 2009. I moved a motion about legal aid services back then. I am a practicing lawyer myself. I started out dealing with legal disputes between Hong Kong and the mainland. Many businessmen from Hong Kong face litigation issues, in particular criminal cases on the mainland. So there were Hong Kong people who got into trouble on the mainland to seek help from me. I offered help to at least 3 Hong Kong people who faced these challenges, and I was involved in over 100 such cases. There was a pair of twins who was forced to separate from each other on the mainland. Well, these clients, when they came to us, they had no money. Even if they had had money, their money was gone because the case dwelled on for over a year. So there was pressure from the public because the victims had to launch press conferences. So back then I was thinking, for some very serious cases, for example, in cases where the clients may face a life imprisonment or a death sentence, could we offer more help? For permanent residents from Hong Kong who face such problems, can we offer support to them? We have many GBA lawyers. I myself is a qualified counsel in the GBA as well. I am also a mediator. mediation can be adopted in minor civil cases. However, for major cases, at the end of the day, we need lawyers. How can we collaborate with mainland law firms This is crucial because there are clients in dire situations. So today, I'd like to echo the motion I moved in 2009 about legal aid services. There are many issues we faced with legal aid services afterwards. That's why I sort of dropped the motion or dropped the issue. Today, well, I don't need the director to give me an answer immediately. I just want to tell you that many Hong Kong people are running businesses on the mainland, and they're not familiar with the laws and the situation there. And somehow they got into deep trouble, including criminal cases. So I want to know if there are any remedies to the situation. Madam Chair, this is just a suggestion. I'll ask the director to give a quick response. What are your considerations behind? I thank the member for the suggestion. According to the legal aid ordinance in Hong Kong, the services and support we provide by the LAD litigation support, and cases that involve places out of Hong Kong, we cannot offer any support. The member just now brought up an interesting point. Hong Kong is an SAR, and there have been more and more exchanges between Hong Kong and the mainland. Is there a need for us to step up collaboration with mainland institutions? We've been thinking about this. To give you a simple example, when we conduct means test on applicants, of course, we can have an idea of the applicant's financial situation in Hong Kong, but as for their financial situations on the mainland, it's hard for us to get a grasp of the situation. So in this regard, perhaps we could deepen collaboration with mainland organizations. Could there be cross-border or cross-boundary collaboration? We may think about this. Thank you, Director. I just want to bring this up so that we can study this together. There are many people from Hong Kong living on the mainland nowadays. We can have initial support for these people. What I understand from the director is that if we have to put in place a policy, we have to amend the relevant legislations. Next, Mr. Alex Fan. Thank you, Madam Chair. I have two sets of questions. First, about paragraph 17 about the use of AI by the LAD. I am concerned about the carrying out of means tests. An applicant who passes the means test may be getting subsidies or support from other government departments. My understanding is that applicants have to submit many paper-based documents to the LAD for verification. I want to know if the LAD has any plans to work with other government departments such as the SWD or the Housing Department so that you can share your data with these departments. At the end of the day, we want to see automated means test. I want to know if there could be more collaboration among government departments in terms of sharing of data so as to streamline the application process. Now, I'd like to ask about paragraph 18, about the distribution and assignment of legal aid cases. I'm particularly concerned about junior and young counsels and solicitors with relatively less experience. Currently, each counsel and each solicitor faces a cap in terms of the number of cases that he can take up every year. Paragraph 20 says that the LAD would assign cases directly to panel lawyers. And the last sentence here says they would assign more junior counsel to take up suitable cases. This deserves our recognition. The LAD has been making use of public funds, so that's different from the practice in the private sector. I understand that you have to take into consideration the competency as well as the expertise of various lawyers, but I hope you would also assign more cases to junior counsels and solicitors. Now my question is, for civil cases, the cap is 30 and 15 respectively. For JR cases and other cases is 5 and 3 respectively. For this assignment limit, would you adjust it? Do you have any specific targets? For example, in the coming 1 to 2 years, perhaps you could adjust the assignment limits to a certain level? Director.
Your first question concerns artificial intelligence. The LAD, as a government department, the CE in his policy address last year, as well as the budget, they both mentioned the application of AI. This is really our responsibility. We will be actively reviewing the use of AI at LAD. In recent months, we have numerous meetings and receiving presentations. Some suppliers are already reaching out to us, telling us what kind of artificial intelligence can we use at LAD. First of all, we have to be very cautious about security issues. Are they local suppliers? Would they be coming from foreign countries? Also, when using AI, there might be issues of hallucinations. For example, if you're just using AI to do R&D on legal cases, sometimes they may make up some case laws. So we have to be very cautious in using AI. As Mr. Fan has mentioned, some AP also needs to supply a lot of documents. Well, and it not concerns AI. We are actively considering going electronic. Can we provide convenience to the AP so that they don't have to submit copies of documents? But still, LAD is handling cases of applicants who are coming from the middle class or even from the grassroots level. It can be difficult if we require them to provide submissions through electronic means. And my time is almost up, but I still want to respond to your second questions. In the document, as I have mentioned, we will encourage more junior lawyers to take up legal aid cases. This has always been our direction. Having said so, we are making use of public fund. So we can't use public funding as a training tool to nurture young lawyers. This is truly a challenging task. Let me cite an example. The Bar Association have a very good system. They will provide scholarships to junior lawyers. So through the scholarship scheme, they will receive payments and accumulate experiences in handling legal aid cases. They can play any roles. They don't have to be the advocate. They can do legal research. Still, they would be learning from that. These are some of the ways for us to encourage junior lawyers to take part in legal aid work as early as possible. Not just the Bar Association, I also welcome suggestions from the Law Society of Hong Kong so that young lawyers can get in touch with legal aid works as early as possible. Thank you. Well, because of time, I will have a tighter control on time limits. Next, Mr. Tan Ka-Pyu. Good afternoon, Director. I have 2 comments and 1 question. Well, I am not a member of this committee, but I would like to extend my gratitude to Legal Aid Department because you are safeguarding the right as well as the justice for the grassroots citizens. Well, I have been a counselor for many years. There are cases that I found very remarkable. There was a young person in 2016 called Singh. He was being deceived by a gym club to borrow money, and they are eyeing on the inheritance that they have received from his parents. It is for the first time that the Legal Aid Department helped this family on the grounds of unreasonable causes. Well, also during the COVID, there was a rather young assistant engineer who worked in a construction site. He passed away very quickly because of COVID, and he was confirmed to receive injury compensations. There was another case from a family in Chun Mun, the baby called Su Yi. They will also benefit from the help of Legal Aid Department. Thank you for your work. In terms of resources, I will continue to support you all. Second, as Mr. Nick Chan has mentioned, about the assignment of counsels regarding criminal cases. I still remember the discussions we had back then. Well, consistency is very important. Let's say today, if a member of the general public has to present himself at the tribunal, let's say the Kwun magistrate or Chunwon magistrate, when he or she would like to seek help from a lawyers, he or she would not make their own choices because it's just one off. So I believe that this is something reasonable. Second, I also noticed that on a certain platform, the director has mentioned that you have already rolled out over. You have already approved applications of people from Wangfu Court. There are over 70 cases. I am also helping them. I would like to ask the director, what kind of applications were they? Do you expect even more applications? Or, well, since it was an event over 6 months ago, do you think you have more or less received all of the applications? Thank you, Chair Lady, and thank you for your question. Regarding the applications from Wangfu Court, at different interviews, I've spoken about them. I would like to provide you with some updated data. As of last Friday, that is the 24th of April, we have received a total of 491 applications. For legal aid that we have approved is a total of 121. Among the 121 cases, part of them have lawyers assigned to them. It would be difficult for me to estimate if the number of cases will continue to increase. Because, well, as we're told by the applicants, they said that the case can be adjourned because they are also looking at other factors before they can decide whether they would like to continue with the proceedings or the application of legal aid. That's all from me. Director, are you still taking care of all the 491 cases? We have received 491 applications and we have approved 121. So it doesn't mean that you will only approve 121 cases. Please clarify. That also includes cases that we have denied, since there are means test and merits test. Some of them cannot pass the mean test. They will be denied. Can you tell us what are the types of applications? It's personal injuries. As you can guess, most of the applications concerns loss of property, some economic loss, and also some compensation on personal injuries. These are what we can expect. Do you have the numbers of the cases you have denied? It's okay. Perhaps you can supplement it after the meeting. I do have the numbers. Among the 491 cases, we have denied 22 cases. But you haven't finished processing. That is the total applications that you have received. No, we have finished processing all of them. We have approved 121 cases and denied 22 cases. For the rest, the applicants have applied for a suspension on the applications. Thank you. Mr. Dennis Lang. As the Bar Association, Law Society, and the Legal Aid Department all mentioned, the existing legal aid system is here to support those who lack economic means so that they would have access to justice. to help them pursue or defend in a legal action. I applaud the previous work of LAD. Looking at the statistics, well, of course, there are cases that successfully approved, and some cannot pass the mean test or the merit test. For those who fail to pass the test, how would the legal aid department continue to support them? Would you provide them with some professional advice so that they will still be able to seek justice afterwards, because there is no mentioning of subsequent works? Second, well, from my association, we also deal with some employment disputes. People told us that the process of applications is not free of issues. As I was still a district councillor, many members of the public will come to us with a form because they don't know how to fill it out. I think it would take us around 4 hours to fill out just one form, even 6 hours. Even for signature, they might have to sign for at least 30 minutes because we need to prepare so many documents for LAD. There is also a very stringent means test. In the past, they will only look at the salary as well as the bank account, but now they will also check the previous balance or the previous record of some e-wallet. Well, some members, if they have an account at the jockey club, it will also be checked. And the documents is not comprehensive enough. There is insufficient reminders for the AP so that they know what they need to provide. In the future, can you be clearer about what you need to look at? Can you provide us with more examples or some template or just a checklist so that the AP would have a better understanding? Now it's very convenient for them to submit the form. You can either do it by post or to authorize certain people to give it by hand on your behalf. Well, but when there are issues discovered, people will post back 1 to 2 months later, and it is far from ideal. In the future, would there be any improvement measures so that they will have a better level of satisfaction? Thank you, Chair Lady, and thank you, Mr. Lang. The first question is regarding the mechanism. If the case is being denied, what will be our subsequent actions? Well, actually, all of them can appeal to the judge for an appeal at the Court of Appeal or the Court of Final Appeal. This is what we support them. That is an independent committee who hears the case of appeal. But of course, the legal aid department will also explain the reasons of our denial. Therefore, we have an existing and very complete appeal mechanism. In the process of applications, people also mention that it is very complicated and it takes hours for one to fill out the form. Surely there are a lot of forms. As you have rightfully mentioned, since our societies is progressing, we have multiple sources of income. There are also multiple types of accounts. And we are here to keep the gates because we're using public funds. Therefore, we have to be stringent in our vetting process. Let's say the Inland Revenues Department or the records of the Social Welfare Department. Sometimes we would require a consent from the AP to allow the LAD to ask all these different government departments. That's why there are numerous forms for them to fill. My apologies, but they are necessary. Each and every form we ask them to fill is necessary. Well, in the future, I definitely would like to see if there is room for streamlining. Can we make use of INT? This is what I've been looking into since I come into my position. Your comment is well taken. We will try to streamline and expedite the process. Chair Lady, I'm not asking for streamlining, but there can be some user manual. Can you be more clear or specific about your requirement in your user manual? Well, to legislative councillors or district councillors, if we are there to help them, we will have a checklist to follow when we want to offer help. Well, actually, we have prepared different pamphlets. There are pamphlets regarding different questions. I think the Deputy Director has brought them here. One of my role is to review these pamphlets so that it will stipulate the requirements more clearly. Next, Mr. Holden Chow.
Thank you, Madam Chair. I thank the Director of Legal Aid. After he has assumed office, he's been communicating with us members on the future development of our legal aid system. This is a great attitude. This is because only through communication that we can make things work. Now, I believe you would all agree that the legal aid department plays a very important role in our society. I'd just like to make one comment today. At this panel, there were other members who brought this up before. The payment to lawyers who took up criminal cases is different from that to lawyers who took up civil cases. In the past, after a lawyer has finished a criminal legal aid case, they got a payment based on the CPI as well as the inflation rate. However, for those who take up civil legal aid cases, the amount of money they get is different from those who take up criminal legal aid cases. I'd like to speak for the legal sector. Those who take up criminal legal aid cases, they spend the same amount of time compared to those who take up civil cases, and that's not fair to those who are assigned criminal cases. I want to know if there could be a proper review on the existing mechanism. I'm not sure if I'm right on this. I just want to discuss this with you all. For civil cases, even if the LAD wins, you get the legal costs. For criminal cases, you represent the defendant, and if you win, you don't get any legal costs. I see that the director is laughing here. The problem is that if we do not review the payment for lawyers who take up criminal legal aid cases, it's not fair to them. Even if you go and claim costs with the DOJ, that's the same thing. So my view is that we need a review. At the magistrate court level, even though the duty lawyer scheme is another system, all lawyers know that the duty lawyer scheme is very helpful to members of the public and also to the legal sector. This is because some very junior counsels and solicitors, they accumulate a lot of experience under the duty lawyer scheme. For senior counsels, they are still serving the duty lawyer scheme. So for those who take up legal aid cases above the magistrate's court's level, I hope that if they are assigned criminal legal aid cases, they can be paid the same amount or similar amount to those who take up civil cases. Director, I thank Mr. Holden Chow for the comment. He talked about the rate for lawyers who are assigned criminal legal aid cases. We have discussed this for years. There are two kinds of reviews. One of them is done biannually, and the rate is adjusted based on the CPI. And this is sort of an automatic adjustment. The other review is done once every 2 years. After I've assumed office, I have been in talks with the two professional bodies about this. We're open to your views, and we would look into this. As mentioned, we are using public money. Well, the Bar Association as well as the Law Society are here. Perhaps they could offer their comments to us on how we can review the mechanism. Then perhaps we can come up with a specific plan on how to follow up on this. This is not the first time we've discussed this. Well, I hope the two professional bodies would offer help. Mr. Holden Chow, do you have any declaration of interest? No? Next, Mr. Wu Yingpeng. Thank you, Madam Chair. I thank the director for leading the LAD in completing a lot of work, especially providing legal support to the wrongful court victims. I'd like to ask about paragraph 6 of the paper. In 2025, the number of JR cases, there were 728, of which 588 have to do with non-refoulement claims. In the same year, the 138 approved JR cases, non-refoulement cases, accounted for about 134. Members of the public are of the view that non-refoulement cases and claims are taking up a lot of public resources. We're focusing a lot of our resources on non-refoulement claims. I'd like to ask about the relevant expenditure incurred, as well as the administrative resources spent on these cases. Are there quick screening mechanisms to speed up the processing of this kind of non-refoulement claim applications? Director. I thank the member for the questions. On JR-related legal aid cases, as said by the member, there are relevant figures in paragraph 6 of the paper. And a lot of these JR cases are related to non-refoulement claims. There were only 4 other JR cases last year, so non-refoulement claims account for a very high percentage of JR cases. As for other JR cases, they only account for about 10%. As mentioned, most of the cases we got are matrimonial cases as well as personal injury claims, and they account for 80% of the legal aid cases we have. So I'd like to tell the public that JR cases account for a very small number of our cases. But I agree that among the JR cases we have, non-refoulement claims account for the vast majority. I won't call this a phenomenon, but this sort of shows that we have justice in Hong Kong. Under our legal aid ordinance, we do not consider the nationalities of applicants. That is, you don't need to be a permanent resident in Hong Kong to apply for legal aid services. And that's why we see a high number of non-refoulement claims. And this is not a problem of the LAD. I see that the court is under a lot of pressure as they are faced with lots of non-refoulement claims cases. So we have been frequently asked how we can be more proactive in dealing with the backlog and how we can better play our role. We've heard the members' views and will continue to follow up on these cases. Any follow-up questions? No. Well, all members who have asked to speak have already raised their questions. Here, I'd like to thank the Deputy Director of Administration as well as the Director of Legal Aid. We hope that you would continue to take forward your work. I also thank the representatives from the 2 legal bodies. Now we're going to wrap up this item. We proceed to agenda item 4, arrangement on mutual service of judicial documents in civil and commercial proceedings between the Mainland and the Hong Kong SAR. I'll ask the Secretariat to invite the administration to come in. We have with us today Mr. Paul Lam, Secretary for Justice, Mr. Llewellyn Mui, Solicitor General of the DOJ, Ms. Lorraine Chen, Deputy Solicitor General of the DOJ, and their team. They are here to brief us on the item today. And from the Law Society, we have Mr. Roden Tong, as well as Ms. Callie Lam. From the Hong Kong Bar Association, we have Mr. Martin Wong, as well as Ms. Connie Yao. Members who would like to speak, please press the Request to Speak button. On the 18th of December 2023, the DOJ briefed members of this panel on the arrangement on mutual service of judicial documents in civil and commercial proceedings between the Mainland and the Hong Kong SAR. We are happy to see that there has been some great progress. Secretary, when you're ready, please walk us through the paper. Thank you. Madam Chair, members, I'm happy to be here to brief members as well as the representatives of the two legal bodies on the arrangement we entered into with the Mainland last week in Beijing. The arrangement is to take forward the policy rolled out in the 2023 policy address. This is also to facilitate the response to the demand of the people in need, as well as to facilitate harmonization of rules between the two places. Now I'd like to give you some background. In 1999, Hong Kong and the Mainland entered into an arrangement, and the arrangement is known as the 1999 arrangement. This arrangement ensures that both places could serve on each other judicial documents. It's been 27 years, and there was a significant increase of judicial documents served between the two places. According to the Supreme Court, from 1999 there were 359 cases, and in 2024 the number increased to about 2,300. Over the years, we got feedback from citizens as well as statutory bodies about difficulties with service of documents. There are recipients who are at unknown places. However, even with addresses, some documents could not be served effectively. Without new modes of service, we could not make sure successful service. For some cases, they are at the primary court level as well as the intermediate People's Court level. And some of them, the documents have to be first served to the one organization and then to the High Court of Hong Kong. Also, according to the 1999 arrangement and the relevant rules, the Hong Kong court has to be entrusted to make sure that the documents could be served. The success rate has been low, so we have to move with the times to update the 1999 arrangement. Therefore, the SPC as well as the DOJ has come up with a new arrangement. This is not a completely new arrangement. Instead, it is an enhanced version of the 1999 arrangement, and it will replace the 1999 arrangement. In relation to the scope of application of the new arrangement, it only applies to mutual service of judicial documents in civil and commercial proceedings between the Mainland and Hong Kong. It won't apply to criminal cases as well as, for example, judgments made in civil and commercial proceedings. The new mechanism is ensure successful service. First, there will be new modes of service. Under the new arrangement, there will be more flexible options to enhance efficiency. Under the new arrangement, documents could be served by electronic means as well as by post. Also, in Hong Kong, for example, we would authorize the authorized organizations to serve the documents, and in the Mainland, notarization institutions could help serve the documents. Also, if documents could not be served through the above means, the documents could be served by public announcement. Also, under the new arrangement, intermediate people's courts as well as primary people's courts could entrust the courts in Hong Kong to make sure successful service. Also, the two places would explore transmitting documents through electronic means. Now I'd like to talk about how we prevent abuses and to offer protection. I have to stress that cross-boundary service have to be permitted by the courts of the two places. There are stringent requirements on how to ensure successful service to protect litigation parties. The courts of the two places will serve as gatekeepers. In general cases, applicants from Hong Kong will have to obtain permission from the High Court in Hong Kong to apply for document service. And there are stringent requirements that they have to comply with. On the mainland, the court in the mainland is the major body that helps serve the documents. Under Article 15 of the new arrangement, it is only with the approval of the mainland courts that authorized parties or persons could help serve the documents directly. Mainland parties could not, without permission, directly serve the documents to the Hong Kong party. In relation to protecting the right to know about the litigation, we have to make sure that the recipient will sign on the acknowledgement receipt to make sure that it is a valid service. Also, the signature could be done electronically. In some cases, there might not be written receipts, but if the recipient mentions the relevant content of the document, it could be determined that the documents have been served.
If the document cannot be served, it will be served through public announcement. We will have a period of 60 days. While the public announcement media will be selected as information network with disseminating power and influence in both mainland and Hong Kong. I would like to also brief members about the next steps of works. Although it has already been signed last week, but it will not come into effect immediately. We have to go through different procedures, including the negative vetting in Legislative, as well as the amendment of existing ordinance. We will have complete consultations with related parties in Hong Kong, including the two legal bodies. At this moment, we are working together with the legal bodies of Hong Kong as well as the FPC in mainland China to nail down the remaining details. Our target is to table the amendment rules in Legislative in the fourth quarter of 2026 so that it will be put into practice within this year. That's all from me. I welcome members' comments and questions. Thank you. Now I would like to invite members from Bar Association, Mr. Martin Wong. Please restrict your time to be less than 5 minutes. Thank you. I would like to express two standpoints on behalf of Bar Association. First of all, under the new arrangements, it can rightfully reflected the advancement of technology in both mainland and Hong Kong since 1999. Modes of communications is no longer restricted to paper form or by post. Many communications are done in electronic forms. I believe that this is just catching up the development of the latest technological communications modes. Well, if we look at the operation of the new arrangement, we believe that it will resolve some practical issues. Allow me to share with you all. I have asked colleagues at my office, perhaps almost all of them will have at least one story about failing to serve the documents in mainland. From the document of the OJ, statistically speaking, I think the success rate is only less than 50%. And we echo that. Therefore, we do welcome the administration to look for ways of new technology in order to perfect the mutual service of documents in mainland and Hong Kong. Therefore, we would like to express our welcome to the new arrangements. We also look forward to the working out of the code of practice and the guidelines. We look forward to providing you with our comments and all the help that you need. Thank you, Chair Lady. Thank you, Mr. Martin Wong. Next, I would like to invite Mr. Roden Tong, President of the Law Society of Hong Kong. Thank you, Chair Lady and members. Well, in terms of laws, economy, and society, Mainland and Hong Kong are having closer ties than ever. As mentioned, well, the cases of mutual service in 1999 is only 559, and in 2024 is 2,399. And the successful rate of both Mainland and Hong Kong are both lower than 50%. We believe that the existing arrangements have serious issues of delay. It is difficult to fulfill the actual needs of cross-border civil and commercial proceedings. The new arrangements build on the foundation of the 1999 arrangement, and it is also responding to the request of the sector regarding the enhancements of effectiveness. Through our visit to Beijing at SPC in 2023, we have expressed our views regarding the mutual service of judicial documents between Mainland and Hong Kong. And in 2024, we had visited SPC again, and they showed that they would like to accept our comments and look into how they can improve the arrangements on mutual service. We would like to express our gratitude, and we will continue to follow it up. And in 2025, as we once again visit the SPC at Beijing, we also speak with the representatives regarding how we can enhance the efficiency of mutual services between Mainland and Hong Kong. We have deepened our communications. It shows that the Hong Kong sector is expecting to further enhance the effectiveness. Since the DOJ disclosed that they have already signed such agreements, we are already collecting views from members. In the future, both the Law Society and all our committees will look at the details of the arrangements and to explore content in different areas. In terms of practical guide and the actual operation, we will also provide our suggestions. Initially, we would like to express our welcome to these new arrangements because new modes of mutual service has been added, including authorized person, electronic modes, etc. And if all means failed, it can also be served by public announcements. These new additions is very timely, and it also serves the needs of cross-border legal needs. It is responding our pressing demand in terms of flexibility. The introduction of serving documents through electronic modes is a breakthrough. We hope that in the future, as we amend the future ordinance, there will be the provision of user guidelines as well as code of practice, so that there will be stricter requirements on the confirmed receipt of service in order to prevent future disputes. And also, there has to be details regarding how many attempts shall there be before we activate the mechanism of service by public announcements. It will allow us to uphold consistencies and reduce unnecessary disputes. We also welcome the list from both Mainland and Hong Kong about the information networks that we can use to publish announcements. We have to look into the coverage of those media. For those in Hong Kong, you may also consider those who are outstanding and information network as well as digital news outlets that are confirmed to be credible. The Law Society also hope that when DOJ is promoting the local execution, you will have close communications with us so that we will understand the conditions as well as the practical guide of putting into practice. We believe that it will, on one hand, enhance the efficiency and to make sure the justice in procedures. It will be instrumental in speeding up the collaboration between the two places. we will try our best to support the work of DOJ and to brief our members in making use of these new arrangements. We will organize or co-organize training courses or seminars so that members will deepen their understanding about the details of the new arrangements regarding the use of different modes, conditions required, etc. Through our communications with mainland lawyers, we will also encourage mutual trust between the two sectors. We will, with our best efforts, ensure that our professions will understand the new arrangement and also make sure that it is serving the purpose of protecting the client's rights. And it is also solidifying our positions as an international center of legal dispute resolution. Thank you. Now, there are 7 members who have expressed their intent to speak. Mr. Alex Fan, Mr. Wu Yingpang, Dennis Lang, Maggie Chan, Thomas So, Nick Chan, and Ms. Priscilla Lang. 4 minutes. Questions and answers include. Mr. Alex Fan. Thank you, Chair Lady. First of all, I really appreciate the effort of DOJ. Thank you for working with our SPC so that we can reach this consensus. As members of both legal bodies have said, it is beneficial to the residents in both locations. I would like to focus on my questions on Article 14, that is service by electronic means. I'm looking at Annex 3, that is the flow chart, to serve by mainland to Hong Kong. I would like to put emphasis in this regard because while it is making use of Article 14, that is, they will use the electronic form to serve the judicial documents. Well, at this moment, we are using the SPC rules. We are focusing on the service of the judicial government in the court of first instance. Normally speaking, if we are focusing on the service of judicial documents of the cases of first instance, normally we would not accept electronic transmission. Under this arrangement, if we roll out electronic transmission here, would there be inconsistencies with our local mechanism? After the arrangement is effective, would we be also including electronic transmission as a service of document ways? There is also a list of conditions regarding when we can use the electronic transmission means, that is to safeguard procedural justice. But the key of our question is, how can we harmonize it with the local mechanism? Thank you. Thank you, Alex, for your question. For sure, we are not just talking about the service of judicial document, but the existing system in Hong Kong. We ask about consistency. I think we have to respect the respected bodies. We have representatives from the judicial bodies here. Maybe they can express their views on this. From my understanding, I don't see huge discrepancies here. Well, Alex, let us discuss some legal issues. You are talking about original summons documents. Well, of course, in black and white, we do not allow serving by electronic transmissions, but in reality it is happening because in Order 65 Rule 4, we have the provisions of such arrangements. In reality, from my experience, when we have to serve by post or serve by hand, if they all fail, then to the court we can require it for a special arrangement, that is electronic transmissions. So it is not that this is not happening already, but do we have to pull it in a written form so that it can become our policy? I think I have to defer it to the judiciary bodies to consider that further. My apologies. I have to introduce other representatives from the administration. Ms. Zhang, Deputy Judicial Administrator, would you like to express further? Thank you, Chair Lady. Well, I think we do have to look into this matter further. As of today, well, regarding some local court proceedings, because there have been some amendments made already, we are introducing e-proceedings. For High Court and District Court, we are already rolling out different kinds of e-proceedings which accept documentations of electronic means. During e-proceedings, as long as both parties agree, they already can transmit documents through electronic means. Well, because not all court proceedings are becoming e-proceedings, so maybe not everybody is aware of that. However, it already exists locally. In the future, how can we handle it regarding the cross-border cases? We have to discuss it further with DOJ, and there might be some amendment of laws even.
多謝先。
I thank the judiciary as well as the secretary for their response. I'd like to ask a follow-up question about originating documents. If you're in a litigation proceeding, the originating process is more important than the rest of the proceedings. Say the proceeding has commenced and the defendant pleads guilty, then it doesn't matter what kind of modes you adopt to serve the documents. So I am most concerned about the originating documents. Anything to add? Well, I can study this further, but my understanding is that if we have the consent from both parties, then the originating documents could served by electronic means as well. Next, Mr. Wu Yingpeng. Thank you, Madam Chair. I thank the Secretary for the introduction. First, I welcome this new arrangement. As a lawyer of both Hong Kong and the mainland, I understand how difficult we are able to come up with this arrangement. This arrangement can ensure efficiency as well as to save costs, and this can help protect the litigation parties, and this also responds to the calls of the National 15th Five-Year Plan to ensure harmonization of rules and regulations. Paragraph 22 of the paper says both sides plan to publish a list of media available for effecting service by public announcement, such as the People's Court announcement. In relation to the list of media, apart from the media announced by the mainland authorities, will it cover, for example, newspaper or social media accounts of Hong Kong? Also, in relation to information networks with disseminating power and influence, I want to know what are the criteria for you to decide which media is with disseminating power and influence? Secretary, well, we don't have a finalized plan yet. The basic requirement is that the media has to have disseminating power and influence. Serving documents by public announcement is the last resort. Under normal circumstances, through public announcement, the parties concerned should be able to get the information they need. As for which media have disseminating power, we have to look at the authority as well as the level of recognition of the media platform. We cannot come up with immediate examples here. During our talk with the SPC, they said they would publish a list. I believe there will be instructions from the mainland as well as interpretations from the mainland in this regard. My understanding is that the courts concerned will have to accept that the information network is effective. If you have any comments or suggestions, we will reflect them to the judiciary as well as the mainland authorities to make sure that we would make a full consideration to the comments and suggestions made by the legal sector. Next, Mr. Dennis Leung. Madam Chair, I thank the governments of Hong Kong and the Mainland for their efforts in facilitating the mutual service of judicial documents in civil and commercial proceedings between the Mainland and the Hong Kong SAR. There were previously 9 arrangements, and this latest arrangement will replace the 1999 arrangement. I have 3 questions. According to previous information from 1999 to 2024, the success rate was less than half, or 50%. Some of the cases could not be dealt with for various reasons. For failed service, did they have any impact on the system in Hong Kong, and how will the arrangement help improve the reputation and the image of the legal system in Hong Kong? Lastly, on service by public announcement, service is deemed effected on the expiry of 60 days after the date of the announcement. Can this service mode be deemed as a last resort, and can you guarantee that the service is successful after 60 days? Secretary. It is true that the success rate was low in the past. We have to understand the importance of the service of document. Like Mr. Alex Fan said, the first step of a litigation proceeding is to serve the document to the other party. If you cannot even serve the documents to the other party, you cannot trigger the legal proceeding, because there's nothing lawyers could do if the documents could not be served to both parties. And this has to do with due administration of justice. The crux of our legal system is about successful implementation. If we can't even trigger the legal proceeding or even serve the documents, then we wouldn't be able to effectively allow people to exercise their rights under our legal system. And that has to do with the rights of our public. Second question is the service by public announcement, the highest level service. Well, as mentioned in Article 3, this should be considered as the last resort. If you have adopted all service modes and you still cannot serve the documents to the party concerned, then the legal proceeding could not be commenced, and we don't want this situation to happen. Therefore, we allow people to serve documents by public announcement. So this is a last resort. This is to make sure that litigation procedures would not be hindered just because of a failed service of document. Next, Ms. Maggie Chan. Thank you, Madam Chair. I thank the judicial organs of the Mainland as well as Hong Kong for their hard work over the years. From 1999 to this year, it's been 26 years. And finally, we see an updated arrangement concerning mutual service of judicial documents. From 2022 to 2025, I served as an MPC deputy, and as LegCo member, I have been calling for more effective service of judicial documents between the two places. We attach great importance to this, and as Secretary said, we have been striving for this for a long time, so I appreciate the effort of the administration. Now I'm looking at the paper. Article 14 states that electronic modes of service could be one of the means for serving documents. I believe electronic means would cover social media platforms or softwares that are frequently used. For example, WhatsApp from Hong Kong. If you get a single tick, it doesn't mean that you cannot successfully deliver the message. Take WeChat from the mainland as an example. A lot of times, users do not use their real names to create a WeChat account. And it's hard for you to verify the actual identity of the WeChat user. So I hope that there could be interpretations from the mainland to deal with these issues. Now, on serving documents, on the Hong Kong side, there is often affirmation of service, stating the service mode. In the mainland, in arbitration proceeding, there are sometimes postal delivery records, and they make use of EMS. Oftentimes, according to the electronic system, it says the document has been served. But under the EMS or the mainland postal delivery system, they do not require the recipient to receive the documents. Their family members, for example, can help receive the documents. So when we implement the arrangement, I hope that there could be more facilitation measures. For example, be it the law firms here or the courts in Hong Kong that help serve the documents, I hope there could be some kind of affirmation stating that the documents have been served based on the agreement of both parties. I think it would be better if we have such arrangement in place. Otherwise, you cannot make sure effective service or valid service. Lastly, on fees, would there be some form of instructions on the fees to be charged for cross-boundary service? Sorry, Madam Chair, my last question is more important. The previous comments were more like my suggestions. Secretary, I thank the member for the suggestions. As we finalize the details of the arrangement, we have to discuss with the mainland. We will definitely pass on your concerns to the Supreme People's Court so that when they formulate their own instructions, they would take into consideration our concerns. The member asked about how a service could be confirmed if the documents are served through social media platforms. Well, of course, we'll have to look at actual evidence, and we'll have to look at whether there are different instructions from different social media platforms. Also, the member said the postal system in the mainland is different. Let's look at Article 13. Say the SPC serves the document on someone in Hong Kong, and they will need the acknowledgement from the receiving party so that the service is deemed effective. We ask the recipient to sign on the receipt as an evidence. Say there is a claim form or claim document, and you've received it, and that's why you respond to the claim, and clearly the other party has received the claim document. In other cases, it is clear that the recipient did not get the documents, and that's why it leads to certain outcomes. We will follow up with the SPC to see how we can finalize the details. As for the question about fee charging, we haven't had a chance to discuss this with the mainland. As far as I understand, this is not of the highest concern of relevant stakeholders. However, I will talk to the judiciary as well as the mainland courts about this.
Thank you, Mr. Thomas So. Thank you, Chair Lady, and thank you, Secretary, because we have been waiting for such arrangements for a long time. We know that you have put a lot of effort into it. Just now, Maggie Chan has mentioned it extensively. I believe that as a deputy of NPC, I have already mentioned it since 2020. I really appreciate your effort. I'm aware that there are details that needs to be nailed out. There also needs to be some follow-up actions on Hong Kong's side. There has to be some subsidiary legislation. Perhaps we can wait till we receive those documents before we can submit our advice. I don't want to waste your time on those issues. When I look at your documents, I see that you plan to complete the procedures within this year. And I am aware that second half this year, DOJ has a lot of items in your pocket. I hope that you can all complete them. I also want to ask about electronic commissions, but Maggie and Alex have already covered it. You have already responded. Third, I have some comments. Well, I am aware that this is an arrangement that we have waited for 20 years. It concerns civil and commercial proceedings. It also, for that document, it takes 10 years to renew. If possible, I hope that the remaining 8 documents, DOJ can put in place a plan so that they can be reviewed on a regular basis. Let's say we have rolled out the amendment of this arrangement. Would it be possible for us to collect comments from users so that regularly we can continue our discussion with our mainland counterparts so that we will be following up and constantly improving the mechanism so that we can truly really serve the national development plan? Secretary, we have been talking about improving this arrangement for years. First of all, my apologies. It takes us years to complete this. Well, but the subsidiary legislation in Hong Kong will be completed as soon as possible. This is a very clear target. We have to do it within this year. Actually, we have been commencing such work in parallel. This is in response to all your demands. Well, there are 9 documents to be renewed, and there are 8 more. Well, regularly, actually, early this year, DOJ has regular meetings with the Supreme People's Court. We are meeting to discuss about the existing arrangements. Perhaps it's not the issues with the documents, but the execution. In practice, we will discover that there are obstacles that are not caused by the legislature themselves. So we are able to achieve certain target, but maybe it is not as obvious, but we are in constant communications, and at the right time we will be sharing with you all. Second, if there are certain obstacles that we discover in the documents, we will also look into that and review it in a timely manner. I hope you understand, because 2 different judicial systems are involved. But both Hong Kong SAR and the mainland also required a lot of internal discussion. My suggestion is perhaps we will take the initiative to invite you all to share your views on a systematic basis, so that when we have regular meetings with SPC, we will be having a better understanding of the sector's views, or you will know that we do concerns about how you feel and we are doing our job. Next, Mr. Nick Chan. Chair ladies, like members, I would like to extend my gratitude to the DOJ. This is an arrangement that we all have been waiting for many years. Upon reading the documents, I have one worry. I think it can be handled. Let's say there are certain documents that are fraud, or maybe there is a fraudulent judge and fraudulent documents. How can we assist those residents, Mainland and Hong Kong included? How can we assist them? Would there be a public registration platform so that people can confirm the recipient of documents so that they can verify whether the document that they have received is true or false? Okay, anti-fraud measures. It is not restricted to judicial documents. Every day we receive a lot of fraud cases. This has always been something that we concern. Surely we are aware of that and we are concerned about that. I can share with you about Hong Kong. If a resident from Mainland are worried that documents from Hong Kong is fraudulent, I think you all know the rules of High Court. Order 63, Rule 4, that should be the one, because I guess that you might ask this question. Anyone is entitled to review the basic information regarding the judicial documents. For example, whether or not such claims exist, what are the case numbers, etc. You can check it on your own, or your lawyers can help you, because there will also be a case numbers. You can just call them or look it up on the internet. I'm sure that this is not an issue in Hong Kong. As for the Mainland, the judicial bodies are aware of our concerns as well. We are in negotiation with them so that they can also reassure us about the authenticity of the documents that they received. There are some simple measures, but I would not share it with the public today. Well, when the detailed policies are being rolled out, I hope that we can provide you all with a guideline so that members of the sector will have the peace of mind. We do understand your concerns. Thank you. Next, Ms. Priscilla Lau. Thank you, Chair Lady. First of all, thank you for the effort of the OJ. This arrangement is surely going to facilitate the handling of cases in the two places. We do believe that we will have a better access to justice. In 1999, I am one of those who promote for the arrangement then. That is the 4 regions over the straits. This is something that is very practical. I really appreciate the mentioning of the last resort, as the Secretary has mentioned. If we have tried all these measures of service, well, including the electronic transmission, in paragraph 19, it has been stipulated that is, the person to be served has to express their consent. And when we have exhausted all means, we still have one safety net. I believe members of the public can understand this. We have really exhausted our means. We also give them 60 days after the announcement is made. To me, I think it's a wonderful arrangement. Second, authorized persons. Apart from law firms and notarization institution, well, as a client, I also sought help and had transactions with law firms in Hong Kong. It is very complicated. Sometimes when I'm too busy, I would drag it for a long, long period of time. Well, because you have to do everything in person. The introduction of electronic service is bringing us convenience. across GBA, in terms of promoting legal services, I believe that this is taking us one step forward. In response to the Secretary's mentioning of a sub-legislation, as well as the newspapers that we can nominate as a means for public announcements, I am quite confident that we would be able to secure those media that are credible. I'm not worried. If they recognize them, if they agree with them, then those must be newspapers of credibility, and vice versa. By then, we can narrow down our options. Since we're all providing professional services, I don't think it will be difficult. I personally support this direction. This is only our first step, of course. We still have to iron out a lot of details. I hope that we can have further discussion then. Do you require a response from DOJ? Well, thank you, Priscilla, for your support. Since 1999 till today, I think she is the single person who understands why we need to improve on this. I also agree that we have to put service first. We hope that it will be efficient. But we also have to prevent the evasion of services. Therefore, there has to be a mechanism of striking a balance. On one hand, we have to be able to trigger the legal proceedings on an effective manner, and also we have to safeguard the rights of defense of those who are served. Most importantly, both sides needs to be able to have a reasonable triggering of legal proceedings and reasonable resources to defend. I would like to extend meeting for 15 minutes. Mr. Julius Ho. Thank you, Chair Lady, and thank you the effort of the OJ. Well, taking Article 15 as my first step, well, reciprocal is the arrangement that we have. I'm talking about, apart from electronic means, let's say we would like to have a postal server or a person or a law firm to serve the documents. Even if the document has been served, I think we have to put it on trial first. Especially people's understanding regarding the service of documents. We also need to understand the mechanism in Mainland. Going back to Article 15, for the Mainland's case, they can do it through a Hong Kong law firm or a registered foreign law firm in Hong Kong. I hope that we can focus on the GBA lawyers or the CAAO. Normally speaking, they are already having close ties with the parties in Mainland, and they have a good understanding about the mechanism. If they are taking over the service of documents, it will be beneficial because they are familiar with it. I think it is well, responding to what Nick said, let's say there is a summons that is served on me. Is it true or false? How can I verify it? Instead of setting up a central platform, it is much easier for you to ring up the local law firms, because since they are the party who serve you, they would know that who was the original party. Instead, if you have to set up a central system, maybe you will be infringing in personal privacy. I'm not sure if it is applicable. This is just a comment from me. Thank you. Secretary, very much appreciated. First of all, I have to give you a token of confidence. Looking at Article 15, well, the Mainland People's Court has to approve it first, so they will be there to keep the gate. As we further communicate the details with them, surely we will express your advice to Mainland People's Court. Shall we arrange for a certain type of lawyers to carry out such works for us, be it GBA lawyers or a CAO? Because they are already familiar with the legal systems in Mainland. They trust them, and Hong Kong people also trust them. It could have reduced a lot of practical issues in execution. will surely reflect this opinion to the Mainland People's Court. On contrary, well, of course, if we are serving someone in Hong Kong, then perhaps they have to have the right of serve of jurisdiction. However, if we have to serve someone in Mainland, who should we seek help from? Would that be someone keeping gate in Hong Kong? Are there certain people who is of a certain standard who can carry out such works? Well, because it is extraterritorial judicial services, would there be such lawyers who can carry out such service? This is one submission from me for your consideration. Well, because the judicial organs will be that should be our gatekeeper. When they grant the leave, there will be different modes and who to approve. There are different things that need to consider. Well, should there be a guidance or conditions when they exercise their discretion? Would there be any practice direction? Would we be encouraging people to use certain lawyers so that we will have a higher chance of success? These are just some examples. When we discuss about the execution or the implementation details, we will surely fully consider what you just suggested. Thank you.
跟住就我直
Now it's my turn. I welcome this new arrangement. With the effort of the DOJ and the SPC, we've got this new arrangement. This is because there are more exchanges between the mainland and Hong Kong, and with this new mechanism in place, we can better ensure justice. As said in the paper, the SPC as well as the DOJ will fully respect the legal systems of the two places to prevent abuse of this new arrangement. I hope that the judiciary could work with the SPC For example, primary people's court as well as the intermediate people's courts would be authorized to help serve documents. And so I think the judiciary should work with the mainland to sort out the relevant details. This new arrangement is subject to negative vetting, and this involves the rule of High Court as well as the rule of District Court, and we need the judiciary to help take forward the relevant amendments. I understand that the new arrangement moves with the times, and we hope that there could be more details in relation to how the judicial organs can verify that the service is effected. Well, these various modes of service are not mutually exclusive. If necessary, the party concerned could adopt more than one service mode. It is just that the applicant could first adopt one mode of service first. Is that right? I understand that you may adopt various modes of service. For example, you can serve the document by electronic means and also by post. And that serving documents by public announcements is the last resort. I want to make sure that my understanding is correct. Thank you, Madam Chair. The judiciary welcomes the new arrangement. All along, we have been cooperating with the DOJ to help facilitate the various arrangements on mutual legal assistance. As mentioned, we have been working with the DOJ. For example, we will work with the DOJ to go through the provisions because we want to offer our comments from the court's perspectives. Also, we would offer help in terms of consulting the relevant advisory committees on the provisions. Also, the judiciary will formulate codes of practice concerning the new arrangement. We will talk to the SPC to sort out the details. For example, members may have noticed that there will be a new transmission platform courts in Hong Kong as well as the courts in the mainland require such platform to ensure smooth transmission of documents. I understand that in the mainland there has already been the first meeting in this regard, and where appropriate, we will talk to the DOJ about this. I believe this can help prevent frauds. Well, this is just one means. Of course, we will continue to discuss this with the DOJ and the SPC. So my understanding is correct. That is, the various modes of service are not mutually exclusive. Yes, as Article 3 said, mutual service between the mainland and Hong Kong may be effected by mutual entrustment by courts as well as in the modes of service agreed by both sides. That is, you can serve the documents in person. You can also adopt postal service as long as the mode of service works. And here it states that if the above service modes do not work, then you can serve the documents by public announcement. That is, the public announcement is the last resort. Well, I think it helps clear things up. I'll wrap up the discussion here. I thank representatives from the DOJ as well as the Judiciary. I also thank the representatives from the two legal bodies. I will conclude this item. Next item, any other business? Thanks to the Judiciary, this panel on the 2nd of June this year will visit the Judiciary. The Secretariat will issue a notice inviting members as well as non-panel members to join the visit. Please note this. There being no other business, meeting adjourned today. Thank you.